Hello, Murray. Good to see you. Welcome, Elizabeth. Good to see you. Welcome back. Yes, it's good to see everybody back. Yes. Oh, hello. Yes. Oh, hi, Steffi. Yay. Yep, we're back. We're back. We've got kind of, instead of one long live today, we've got two kind of shorter ones. So this format just worked out better for me today. So thank you everyone for being accommodating. I appreciate that. Yes, hello. I'm just here for your laugh. Okay, well, there's some good laughs. I've got some laughs for tonight. The judge's order is very interesting. Oh, from Indiana. Well, hello. Welcome. Good to see you. Good to see you. Do I have any friends living in my homestead? A dog or a cat? I don't. I had a cat, but she passed away. So I was too devastated to get another one. But we do have foxes that live in the backyard, so I've adopted them. So I think that's okay. Let's all laugh together. Yes! Well, hello, Tina. Hi, welcome. Good to see you. Good to see everybody. Yes, I do have some. Yes, I'm very thankful for our land here. Actually, my house is on a big plot of land that used to be part of an apple orchard. So it's got lots of like rolling hills. So beautiful to look at, not fun to mow, but I'm very, very thankful, very thankful. So yes, foxes are pretty neat. Yeah, they are. They're really cool. There's a little den out in the back, and so we watch the foxes running around. It's very fascinating. They're very neat creatures. So I appreciate that. Adopt me. I don't require much space. I can't. I've just got too many cases to keep track of. Oh my gosh. Yes. That's so funny. Yes, read the indictments. So I've gone through all of the indictments multiple times, and I've posted up on my Tube of You channel. So if you're ever interested in watching a full readout of all of the indictments, you can catch them over there. So I think Tube of You is much better for long formatted videos, and it works out really nicely then to be able to kind of pull up and fast forward through different sections. So do have that available for everyone. Absolutely. Hello. Good to see you. Good to see everybody. Love it. Love that everyone came back tonight. Thank you again for and anything controversial. Exactly. You got it, Frank. It's good to see everyone back. I appreciate you being so understanding. I needed to split my lives into a little bit shorter formats today. It just kind of worked out better for me. Hello from San Francisco. Hello. Good to see you. Yes, well, hello, Lisa. Always a pleasure. Lisa A and Lisa Love. We love that. Good to see you. And Cece, wow. Oh, wow. Everyone's here tonight. Oh, thanks. Thanks for coming. The Mormon State. Okay, is that Utah? Or is the Mormon State like a frame of mind? I don't know. Hello from Oregon. Yes. Oh my gosh, that's so funny. Hydrate. Yes, I do have. Oh, I do have some. I do have some hydration. For sure. So I hope not. Oh, that's so funny. I was driving home. I couldn't wait to start watching you. Oh, Detroit. Oh, okay. Welcome. Panhandle, Florida. Oh my gosh. We love that. Idaho. Whoa, all around the place then. Oh, from Canada. Nice to see you. Nice to see all of you. We love that. Ohio. Excellent. Maryland. You know, with Ohio, I think I've said this before. I don't get it with the Buckeyes. I don't get it. I mean, I don't mean any offense. I love the Buckeyes, but like, why is the team called the Buckeyes? You know what I mean? Like, is it because they're poisonous? Is it because they're hard? Like, is it a tasty dessert? Like, I just don't get it. I frustrate myself trying to get that sorted. But no disrespect to the Buckeyes. Love the Buckeyes. Upstate New York. Oh my gosh, I bet it's starting to get really beautiful there in upstate New York. I don't get it either. Well, good. Then I don't feel all alone about that. Kansas. Oh my gosh, love it. Northern California. Yeah, the leaves are just starting to turn now, so it's really starting to become really beautiful. Holly Glen, California. Oh, welcome, welcome. In New York again, we love that. It's the state tree. Oh, okay, okay. All right, all right. No, I don't get it still. I mean, so like if your tree was, the state tree was like the oak, you know what I mean? Like there aren't like the oaks. We don't have any sports teams called the Oaks, or the Elms. Like, I'm not saying they can't be. I'm just saying it's just different. It's just a little different. Lexington, Kentucky. Oh, hello. Hello, hello. The LA smog is changing. Oh, my goodness. Oh, my gosh. That's so funny. Oh, the Hoosiers in Indiana. Yeah, I agree. I know. There's some of the desserts for sure. I don't know what a Hoosier is. I know. There's all kinds of interesting bits and bobs, isn't it? Oh my gosh. Yes. Oh my goodness. It's going to be a wild one tonight, everybody. I can just tell. I can tell. Humboldt County, California. Love that. Love it. Oh my gosh. I'm going to have to pace myself tonight. Illinois, okay. You can see Wisconsin and Iowa from your backyard. Oh my gosh, Tony, that's so cool. Wow, that's really cool. Kentucky, Maryland. Oh my gosh, that's really cool. Rhode Island. Oh my gosh. Rhode Island was the last one to sign. They had some taxes issued back in the day when we were doing the Articles of Confederation. I won't go into it too much, but I'm just saying, all the way back in the day. Ooh, St. Louis, hello. You can see Canada? Oh my gosh, that's fantastic. Oh, that's so great. Ooh, Alaska, my goodness. Kenosha, Wisconsin. Oh, wow, everybody from all over the place. Oklahoma, Tennessee. Oh my gosh, we love that. Yes, got rid of the Providence. Okay, very interesting. Arkansas. St. Louis, Louisiana. Did I see Las Vegas in there? Oh my gosh. Wow, everybody from all over the place. My goodness gracious. Well, thank you all for joining me tonight. I really appreciate it. Northern Minnesota. Okay, in California, Manhattan, Carolina. All right. Minnesota, woohoo. All right, so northern Minnesota, is that Canada, right? Is that Canada? Oh, I kid. We love Minnesota. Central Indiana. Oh my goodness. Vegas. Wow. Oh my goodness. Oh, I love it. You can see the dentist's office from your window. I'm not sure if that's good or bad. I'm not sure how to respond to that. I know, Frank, everybody's on fire tonight. Everyone is on. Oh my gosh, it's going to be a great one, I can tell. Oh my goodness. All right, everybody. Okay, so it's 6:01 according to my clock here. So let's dive in. Yes. Hello, everybody. All right, so tonight I want to take you through a Georgia update. This will probably be a shorter live tonight, just because we've only got a couple of updates, but we did have an order that came out from Judge McAfee on Friday, and it's actually a very interesting order. He's starting to let his humor come out a little bit, and I personally I'm living for that right now. So I'm all about that. I'm okay with that. So just as a friendly reminder, this is the indictment for Georgia. We've got 19 defendants listed, although at this point we have one defendant who has pled out. So I'm giving you a warning. I'm going to show you the chart, okay? This is your warning, though. Don't be scared. Don't be afraid. We'll be all right. We're going to make it. So here's the chart. Let me bump it up a little bit. This is the chart of everybody involved with the, I know I'm blind. I I try to warn first. Oh my goodness. I know. Oh my gosh. I know. So this is our chart, all right? All the mugshots. So we've got 19. And of course, we all know Giuliani. We've got the local fake electors here. We've got a few attorneys, a minister here. Miss Hampton, who doesn't have any filings, actually. We have Miss Ellis up here. Now, Sidney Powell and Mr. Cheesebro, these two are the two that are scheduled for the speedy jury trial starting on the 23rd. All right. So really, most of what we've got to talk about will be involving these two players. All right. Now, Miss Latham was a local person too for the fake electors. And now Mr. Hall is the one that has pled guilty. So we did take a vote and everyone decided to just write guilty on his head. So that's how that's going. Oh, that's how that went down. So we also have over here Floyd, Meadows, Cuddy as well, Still, Clark, and Roman. So those are the cast of characters that are involved in this particular case. Yes, he pled guilty because he pled guilty. Yes, he has pled. Oh, he's pled guilty. Yes, it's a very interesting. So this is our cast of characters just to give you some idea. So Mr. Cheesebro and Miss Powell are set for jury trial. Now, most of the filings that we'll go through, and I've just got a couple for tonight because I really just want to focus on the order that came out from the judge on Friday. But Cheesebro has two attorneys. One of his attorneys he's local and he seems to be following the rules. I'm not a huge fan, but he's fumbling through it. His other attorney just keeps filing so many things over and over and over again. It's a lot. So you'll see that in the judge's order. The judge is kind of saying you need to calm down a little bit. I'm going to need you to calm down. So the judge set it out in his order that we'll go over tonight, which is really very interesting. Now, Miss Powell's attorney, very, very polished, used to practicing in federal court. He did a motion to dismiss based off of a Brady violation. Now, Brady means the prosecutors have to give over any exculpatory evidence to the defendant. And so her attorney claimed some information hadn't been given to her. So the judge said, too bad, they've given everything they can, but told the state to go back and check the records. And that's what they're doing. So the motion to dismiss was denied. So that's her update. So we are still on target then for these two to be going to trial on October 23rd. So trial in Georgia begins on the 23rd. But we've got jury questionnaires going out starting here around the 19th and 20th. So things will be picking up in Georgia coming up pretty soon. But until then, until we get to the Kraken, cheese and crackers, that's right. I didn't coin that phrase. I'm not sure who did, but we do have cheese and crackers for trial. Oh no, I moved the form. That's so funny. Oh my goodness. All right. So let's move this out of the way and I'll take you through some of the forms. A couple of the orders. One thing though that I would like to do is I'll walk you through his order that he just had, but then I also want to kind of do a brief overview of the voir dire process that they're going to be starting pretty soon. I was able to kind of print out a couple things about voir dire. One of the motions that was filed was by Cheesebro's attorney asking for more strikes during the voir dire process. So I will go into in greater detail the jury voir dire process to explain that better. So I'll go through the motions in the order first, and then I'll take you through the process here. So, all right. Hawk says it, but don't know if it coined it. Okay, could be. I'm not really sure. Yeah, I'm really not. I'm not sure who it was. I saw it somewhere. Yes, here we go. All right, so this is the order that I will end on, but let's start with, again, and I don't have too much going on here, which is just fine. We do have probably the first thing in Georgia is that we have the hearing on the demurs that is scheduled for the beginning of next week. So on the 9th and 10th, the judge is going to hear arguments about the demur. So let me take you through the motion on demur so that everyone understands what that means when I'm talking about the demur hearing, okay? So let me make sure I'm in frame. Am I in frame okay? Let me move down a little bit here. Double check. There we go. How's that? Is that better? I should hopefully... Oh, Post-it note. Yes, thank you. Thank you so much for your helpful reminders. I appreciate that so much. Okay, we're good. We're good. Let me get my sticky note going here. Great. Good. Okay. Fabulous. We love that. So we have the Georgia case update. All right. So that will be our sticky note here. So let me get going on that. All right, so let me take you through this motion. Again, this was filed by Kenneth Cheesebro regarding the demur. Several other people joined in the demur and so on. So I'll just take you through a little bit of this to explain what the demur is. All right, so comes now Kenneth Cheesebro by and through undersigned counsel and asks this honorable court to dismiss the indictment as his actions as alleged in the indictment are protected by the First Amendment to the United States Constitution and therefore are exempt from prosecution. In support thereof, Mr. Cheesebro states the following. So proposed findings of fact here. So what he has done this entire time is continue to go in and say that the facts as he sees them are different and therefore there's no basis for the charges. Now the judge disagrees, but this is what he's saying repeatedly. So proposed finding of facts. So this is not what the finding of facts are. It's what's being proposed by Mr. Cheesebro. Mr. Cheesebro's involvement in this matter began when he was asked by former colleague Judge James Trupus on or about November 18th of 2020 to provide some research into the 12th Amendment and the Electoral Count Act in relation to allegations of voting irregularities in Wisconsin. Mr. Cheesebro, as distinguished appellate attorney with substantial experience in election law, accepted the task. And then bumping down, saying Mr. Cheesebro was on Al Gore's legal team in Bush v. Gore, which, by the way, Al Gore lost, and a litany of lower court, federal, and state cases fighting over the 2000 presidential election. As his first task, Mr. Cheesebro wrote a legal memo dated November 18th outlining his legal theories as supported by his statutory interpretation, case citation law review articles, historic precedent, and academic papers. Here again, he's citing his paper. Importantly, although the underlying case in Wisconsin, Trump v. Biden, which was originally unsuccessful via 4-3 decision by the Wisconsin Supreme Court, based on the esoteric equitable doctrine of laches, meaning the case was brought too late. When those same issues were fully litigated some months later in Teagan v. Wisconsin Elections Commission, the position advocated by Mr. Cheesebro and Judge Trupus was successful. You're like, okay, great. Mr. Cheesebro was subsequently asked for research and input as to the application of his initial findings in other states where there was a pending legal challenge to the election results, including Georgia. In response, he wrote a second legal memorandum dated December 6th, in which he again outlined his legal theories as supported by his interpretation of statutes, case citations, law review articles, historic precedent, and academic papers. So again, we've got two endnotes. One, Mr. Cheesebro never set foot in Georgia. His only contact with Georgia involved two emails, both sent on December 10th to David Schaefer. Let's just make a note. This is David Schaefer right here. All right, he was one of the fake electors. Number 4, Mr. Cheesebro acknowledges his bold controversial strategy as one possible option, but also states, I'm not necessarily advising this course of action. Necessarily, all right. In December 6th, his December 6, 2020 memo discussed historic precedents such as the presidential election in Hawaii in 1960, where the Kennedy campaign utilized alternate electors after the state had already been called for Richard Nixon, but where there was a challenge pending, as well as lessons learned from Al Gore's unsuccessful election challenge in 2000. But in the end, the memo emphasizes that for the proposed legal conclusions to be actionable, there must be a valid lower court decisions in each state. Again, we've got another end note. Importantly, during the relevant time period, there was a pending litigation in both state and federal court in Georgia. Again, he is arguing the facts in this case in order to have his indictment tossed. That's what his demur is. All right. Over the course of his work, Mr. Chesebro did not provide any guidance as to how to handle any litigation in Georgia. In both his December 6th memo and again in another memo dated December 9th, Mr. Chesebro simply described the process in which the electors are required to be selected, the process for completing the ballots, as well as the deadlines that apply. Based on his legal work for the Trump campaign, Mr. Chesebro has been indicted and alleged to have committed the following overt acts in the RICO conspiracy charged in count 1. So then he lists out what acts he was a part of. So we have an email, we have a memo regarding the requirements for the electoral votes. We have another email, an email. All of these are emails. So all of these emails that he wrote are part of the overt acts in the RICO. Continuing on, we have more emails that he sent and received. So again, we've got 161 total acts, so he's taking the judge through the acts that he was a part of. The American Bar Association's model rules of professional conduct say that an attorney may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. An attorney is obviously prohibited from counseling a client on committing a crime or fraud, but the attorney is permitted to give an honest opinion about the actual consequences that appear likely to result from the client's conduct. The American Bar Association notes the distinction between presenting a legal analysis versus recommending the means by which to commit a crime. I'm not sure why he's citing the American Bar Association. That's not particularly persuasive authority, but whatever. Mr. Chesebro contends that every action he undertook in his role as an attorney for the Trump campaign was protected under the First Amendment, should be excluded from prosecution. So that's the basis for his request that his indictment be tossed, was he said that the language he was using is protected by the First Amendment. Yes, no, he was involved in emails on the 7th, on the 9th, the 10th here, the 11th, 12th, 13th, 23rd, 1st, and 4th. So he was, pretty much intricately placed in the situation. So then he goes in and starts citing authority about this First Amendment argument. Now, I'm not going to spend a lot of time on that because in the end, the hearing is coming up, and so he'll be able to argue it there. So he goes on again into saying, suggesting the use of alternate electors in states where there were pending legal challenges was not knowingly or recklessly advancing a falsehood. Instead, he was relying on legal historic precedent, the United States Constitution, the Electoral Count Act, of which there is no mention of an alternate slate of electors. Suggested that the Republican presidential electors who had been qualified and elected by the Georgia Republican Party, and we all went through that as well. Remember that special hearing that they decided to make a record of at the time? Remember that? Meet and vote in accordance with the Constitution and state statutes in order to preserve any potential remedies following the conclusion of ongoing litigation. So he continues to go on and kind of explain his point with the First Amendment. Again, this is his motion for demur, so meaning he wants his piece of the indictment tossed. The doctor can't recommend arsenic as a remedy, then clean free speech when the patient is poisoned. Yeah, true story. True story. Yeah, you shouldn't do that. Nope. So then we've got Mr. Chesebro provided legal advice. This advice was tendered in the form of a legal memorandum and email communications. So again, he's just arguing this First Amendment issue. So it was argued, but it'll be argued again. He requested oral arguments in front of Judge McAfee in Georgia. So that will be going on at the beginning of next week. So I do want to bump down here to read through this footnote that he included. Especially prudent to the charges alleged against Mr. Cheesebro, the Alvarez decision contemplates the First Amendment protection awarded to statements made by those who are falsely representing that they are speaking on behalf of the government, including speech that results in impersonating an officer or employee of the United States. Defense counsel anticipates that the prosecution will manipulate this language to assert that the actions of Mr. Cheesebro in suggesting an alternate slate of electors strips him of his First Amendment protection because his legal advice furthered the alleged impersonation of government officials and interfered with the integrity of the government process. All right, so that's a key piece. Again, it's because of the language he used in those memos that they went forward with the plan. All right, so that's a really important piece to remember. However, Mr. Cheesebro, in suggesting an alternate slate of electors, was not suggesting that anyone impersonate an officer. Instead, Mr. Cheesebro, relying on precedent, the U.S. Constitution, the Electoral Count Act, suggested that the presidential electors who had been qualified and elected by the Georgia Republican Party meet and vote in accordance with the Constitution and state statutes in order to preserve any potential remedies following the conclusion of ongoing litigation. In no way does this conduct impersonate a public officer. Instead, it advises the alternate slate of electors to act as prescribed in clear black letter law. So this entire argument is what he has continued to go on and on and on about. Basically, he's trying to make this suggestion of alternate electors legal. He's trying to say this was something that is allowable by the Constitution and the Electoral Act, and therefore I did nothing wrong. Which, as we read this morning, the district court has already said there's nothing in there about that. So no, but that continues to be his argument. He continues to put it on even in his motion for a demur. All right, so there you have it. That's just an update again on his motion for demur. That will be argued out Monday and Tuesday of next week. His attorney has also asked to be able to bring in the lawmaker, the senator, I believe, who wrote the Georgia RICO statute to show intent and so on. The judge has not permitted that and doesn't believe that there will be time for that, but Cheesebro's asked for it. So he's done a lot. This attorney has really filed a lot in this case. So all right, next we've got, again, these next motions are all filed by Cheesebro and his attorney. He's filed all of these different motions. First, we have a petition for certificate of need for testimony before criminal prosecution pursuant to the Uniform Act to secure the attendance of witnesses from without the state. So keep in mind, too, I think it'll be helpful if you remember, Mr. Cheesebro requested speedy. So the only reason why this was set for October 23rd is because Mr. Cheesebro and Ms. Powell requested it. So they're coming in and they're saying, we want more time for stuff. We want a longer hearing. We want to bring in more witnesses. We want more time to question. Meanwhile, the judge has this very limited time period in which to take the case to trial, or else the case will be tossed if it's outside of the speedy trial demand period. So it's interesting how he's trying to kind of push the outer limits of the amount of time that everybody has in order to get this case to trial. So here we go. He's asking again for testimony before the prosecution, which is in 2 weeks, and setting out, his reasoning for that. The state of Georgia, goes on, and we've got here his extra bits and pieces that he's asking for. So let's see. The state of Georgia, by and through Fonnie Willis, petitions the Honorable Court for a certificate of need for testimony before a criminal prosecution pursuant to the Uniform Act to secure the attendance of witnesses from without the state pursuant to this section of the code. So they're going in here. Defendant Cheesebro's charged with 1 count of violation of RICO here. Defendant Powell is charged with 1 count of violation of RICO. Arizona resident George Safston is necessary a material witness, specifically for Act 49. The state anticipates that he will testify about his interactions with Cheesebro as it relates to Cheesebro's involvement in the scheme to have Trump presidential elector nominees convene and cast fault electoral college votes in Arizona. On December 10th, Cheesebro sent an email to Greg, which included the draft certificate suitable for Arizona. On the 11th, Cheesebro sent an email for Mr. Safston, specific instructions as to when the Trump presidential elector nominees would meet. All of these emails were sent by Cheesebro to Mr. Safston. The certificate prepared by Mr. Cheesebro sent to Mr. Safston, who then signed it with others on December 14th, falsely represents that Greg Safston and others were duly elected qualified electors. So this is one of the fake electors who's going to be involved in this as well. Additionally, Greg filed a lawsuit against Arizona Governor and Arizona Secretary of State, asking the United States District Court for the District of Arizona to issue an order directing the governor and secretary to decertify the election results, and an order enjoining Governor Ducey from transmitting the currently certified election results. He sounds like he's going to be a difficult witness. The court dismissed this case on December 9th before the casting of the Electoral College votes in Arizona. One of the attorneys representing Safston in this matter was defendant Sidney Catherine Powell. Ooh, oh my gosh. Did everybody see that? We kind of hid the lead on that. We hid the lead on that. We're going to need wine with cheese and crackers. All right, so one of the witnesses the state's going to call, all right, who's going to testify, whether he wants to or not, about the fake electors element, had filed a lawsuit against the governor in Arizona, all right, asking for the governor to toss out the election results. The lawsuit he filed was filed by his attorney, Miss Powell. Did everyone find that? Miss Crackers, yes, Miss Crackers filed that. Right. So the plot thickens. Yeah, the plot thickens here. All right, Mr. Safston, based on the information set forth above, is a necessary and material witness. He possesses unique knowledge concerning communications between himself, Kenneth Cheesebro, and Sidney Powell, other known and unknown individuals involved in the multi-state coordinated efforts to influence the results of the November 2020 election in Arizona, Georgia, and elsewhere. The testimony of Mr. Safston will not be cumulative of any other evidence in this matter. He resides outside the jurisdiction of this court and therefore is unable to be served with process to compel attendance and testimony. He currently resides in Maricopa County, Arizona. He will be required to be in attendance and testify before the trial in this matter, commencing October 23rd. It's not known at this time which specific date he'll be called by the state as a witness, as a jury has not yet been sworn and the presentation of evidence has not yet begun. The district attorney reasonably anticipates Mr. Safston's testimony will not exceed 1 day. The Office of the Fulton County District Attorney in and for the state of Georgia will pay all reasonable and necessary travel expenses and witness fees required to secure his attendance and testimony in accordance with the Uniform Act. So she is explaining that if Mr. Safston comes into the state of Georgia pursuant to this request, directing him to attend and testify in this criminal prosecution, the laws of this state shall give him protection from arrest and from service of civil or criminal processes. So what she's saying here is he will have immunity. So if he comes into the state, he will be immune from prosecution. All right. So this is pretty typical when they're pulling someone in from another state. They're saying, I tell you what, we'll pause everything. If you come into our state and come testify, we won't file anything against you. Both Georgia and Arizona have adopted the Uniform Act to secure the attendance of witnesses from without a state in criminal proceedings. So this is a typical file here. All right. So We're requesting that, and that was submitted then the 3rd of October. So that's the update then from the state. So let's get back then to Mr. Cheesebro and his request for the additional time. Comes now, Cheesebro, by and through undersigned counsel, hereby requests additional time to question potential trial jurors. In support of his request, Cheesebro shows the Honorable Court as follows. So during the September 29th virtual conference in this matter, the court stated that the parties would each have 1 hour to question a panel of 14 potential jurors. So let me pause here for a minute. This has to do with the, I actually did do a live showing this virtual conference, if everyone remembers. Yeah, more time. I know, Frank, I know, right? Is that crazy? All right, hydrating, everyone. Okay. So, if you remember that hearing, the judge had set out some time limits because, we've got 400 people coming in, it's a lot, which amounts to less than 5 minutes per juror. Respectfully, Mr. Cheesebro submits that this is insufficient due to the nature, length, and complexity of this case. Put simply, less than 5 minutes for each juror is not adequate to allow counsel to explore all potential biases, background, etc., or of any juror, and in turn leads to the risk that Mr. Cheesebro will be denied the right to a fair and impartial jury. Now, if you remember that hearing, the judge said each attorney will get 1 hour, so it will kind of alternate back and forth. So both defense counsel, each one will get 1 hour. So I'm not sure about this 5 minute situation. I'm not sure about it. All right, so the single purpose of voir dire is the ascertainment of impartiality of jurors, their ability to treat the cause on the merits with objectivity and freedom from bias. So, this attorney, I'm just not very impressed with him because he keeps filing all of these motions and they seem excessive, but that's my opinion. Although it's true that the scope of voir dire is generally a matter for the trial court's discretion, in exercising the court's discretion, a defendant must be permitted to ask sufficient questions to determine the fairness and impartiality of prospective jurors. For these reasons, in order to ensure Mr. Cheesebro is tried by a fair and impartial jury of his peers, as is his constitutional right, Mr. Cheesebro asked the court to allow the parties additional time to voir dire the potential jurors. All right, so, and then we've got a footnote. Counsel's hesitant to ask for a specific amount of additional time needed due to the unique and unprecedented circumstances presented in this case. So he's saying he wants more time, but he doesn't know how much more time. That he will make that determination as he goes, is what this attorney is saying. Instead, counsel would simply ask that they be able to adequately but reasonably question potential jurors as necessary in order to ensure a fair and impartial jury, regardless of how much time that may take. So he's telling the judge he doesn't want time limitations on his voir dire process. Meanwhile, it's going to take forever to do the voir dire process if the judge doesn't keep the show on the road. If you don't ask for anything specific, yeah, speedy but slow, right? Yeah, that was brave of them to ask. This attorney, oh my gosh, this attorney continues to just ask again for all of these kind of special bits and pieces. And it shows to me he must not have like 200 cases on his desk. You know what I'm saying? Sounds like he's trying to get it thrown out purposely, going over time. It could very well be, Persephone. It's possible. They're keeping a close eye on the clock, but he's the one that requested the clock, and now he's requesting more time. So if he's given unlimited time for voir dire, he could, theoretically ask the jurors questions until speedy runs, technically, because he's asking for unlimited amounts of time. So that's a lot. He's asking for a lot more than what is appropriate. So that then takes us to his last motion, which is requesting additional jury strikes. Okay, so yet again, he's asking for more. This attorney just has so much more that he wants, all right, which is way outside of the scope here. All right, yeah, here's one more. So we have a motion requesting additional jury strikes. So he's asked for more time to do voir dire. Now he's asking for more strikes. Comes now, Kenneth Cheesebro, by and through undersigned counsel, pursuant to this, hereby requests 5 additional peremptory strikes. Now I'll go through this whole strike process here after I finish up with this order, but I'll take you through the strikes process and explain it to you. In support of his request, Mr. Cheesebro shows this honorable court as follows. Georgia law provides that every person accused of a felony may peremptorily challenge 9 of the jurors impaneled to try him or her. Now, again, peremptory just means that the attorneys can strike particular people from the pool that they don't want to have sit on the trial. For a multi-defendant criminal case such as this one, Georgia law provides that in the event of 2 or more defendants are tried jointly, the court, upon request of the defendant, shall allow an equal number of additional strikes to the defendant, not to exceed 5 each, as the court shall deem necessary, to the ends that justice may prevail. All right. In the case at bar, that ends of justice require Mr. Cheesebro receive additional strikes. While it may be accurate, as noted by the court during the last hearing in this matter, that the defenses of Mr. Cheesebro and Ms. Powell are not necessarily antagonistic, which means they're not fighting each other. So their defenses are not reliant on the other defendant to one another. That is mainly because the allegations against Mr. Cheesebro and Ms. Powell, although joined together by the RICO charge, are completely different from one another. Specifically, Mr. Cheesebro is alleged to have been part of the so-called, it's actually not so-called, it is actually called the alternate elector plan, whereas Ms. Powell is alleged to have been part of the so-called Coffee County conspiracy. There's absolutely no factual overlap between the two. The reality of this case mandates the need for more jury strikes. Requiring 2 defendants to share 9 strikes, 4.5 strikes each, is inadequate under the facts and circumstances of this case. To put this point into further perspective, the typical felony case in Fulton County starts with a pool of approximately 40 jurors. 9 strikes per defendant results in nearly 25% strike rate. A typical murder case starts with approximately 60 jurors, resulting in a 15% strike rate. In the case at bar with 450 jurors, Mr. Cheesebro would be faced with a 1% strike rate, reduced to 0.5% when compared to the total of 900 jurors with the received summonses in this case. Now, we're not going to get to 900 jurors necessarily. It's just they've pulled in a whole bunch just in case it takes extra time in order to strike for cause and so on. Again, I'll explain this a little bit more after the order. Given the unprecedented nature of this case, that's simply not enough. Wherefore, Cheesebro requests a total of 5 additional strikes with a comparable number of additional strikes for the state, respectfully submitted on October 3rd. So, he's asking for 9 or 10 strikes per co-defendant. Yeah, 900. Yeah, 10 strikes. Yeah, what's he doing? This person is a little bit different. No, 50 strikes. I want 6 weeks to question the jurors, and I want 50 strikes. It's hard to find people who've not heard about it. That's true. I agree, Navy vet. But I would say, thank you for the reminder, Deserts guys. I appreciate it. I would say it's not necessarily going to be hard, though, to find impartial jurors at this point. I think with these 2 particular defendants, I think if we had Trump as the defendant right out of the gate, yeah, I could see that being an issue. But Cheesebro and Powell, no, I don't think they're going to still have that same issue. They have widened the pool just to make sure they don't have to go back out again. But, you know, in the end, I don't think they're going to be coming up across huge issues. I think it's important to be careful, and you can always ask for more strikes. But what's interesting here is if you look at the aggregate set of motions that this lawyer keeps filing. He keeps asking for more time. He keeps asking for special witnesses. He keeps asking for a whole bunch of extra stuff on top of the fact that he's requested speedy. So it's just kind of a fascinating play that this attorney is saying, hey, we've got to get this case tried. But on the other hand, I want to take all this extra time for all my extra stuff. What are strikes? Yes, I will get into that whole process here in just a little bit. We have, I can do, let's see. He obtained his law degree from Tamu. Oh my goodness. He's delaying and doesn't want to delay. Kind of seems like it. It kind of seems like it. Or he's trying to push, he's requested speedy and then trying to push his request to make it so that speedy doesn't happen, which is possible. Yeah, he hates cheeseburgers, so he's out. So, right, I will go through the process of strikes for everyone. I'm just giving you a sneak peek here. But when we have a whole bunch of jurors come in and we're given a certain number of strikes, in Georgia, in this case, it's 9 each, 9 for the state, 9 for defense counsel. And there's 2 defense counsel here. So we come in, we put their names down, and then if we feel like they're going to not be very good, then we would strike them. And we go back and forth until we've used all of our strikes, and then whatever's left is our jury. But I'll take you through that process in more detail here after I go through this order. To the right, to the right, to the right. There we go. There we go. How's that? If the judge could make this a bench trial because of the stalling tactics. No, I think it's because it's a criminal case. Yep. If this was a civil case, it's possible. It could be possible depending on how the procedural rules are set out. That's a good question, actually. Okay, so let's go through the order. So this is the order that Judge McAfee set out regarding all of these extra filings, okay? So this is the most recent order from the judge. I'll take you through that, and then we'll go through the voir dire process. So, order on defendant Cheese Bros, motion to dismiss indictment for failure to comply. So, Cheese Bro is set out, Latham, Schaefer, and Smith. So, this judge is nothing if not efficient. He's got a jury trial going on right now. This man probably gets maybe an hour of sleep a day. So when he has to put an order together, he's going to put as many people in it as possible with whatever needs to be said in it so he can get it done. So should he have done just Cheese Bros order? I don't know. But he's like, I don't have time for this. So everybody get on the order and I'm going to set out what the rules are. It cracks me up. All right, defendant Cheesebro now seeks dismissal of the indictment because the district attorney's office neglected to file the oath of Special Assistant District Attorney Nathan Wade, an allegation in alleged violation of this code section. So not only has he filed for First Amendment grounds for the demur, which is being argued, he's also filed saying his indictment should be tossed out because Georgia pulled in a special assistant district attorney to be part of their team, all right? And he is saying that this special assistant wasn't given an oath, all right? So you raise your right hand and the DA gives you an oath when you come in on the team. So they're saying he wasn't given an oath, and so therefore everything he's done is invalid and the case should be dismissed. Yes, I know. Can you believe it? I know, it's a lot. Yeah, exactly. Here's the code section. Before proceeding to act, all deputies shall take the same oaths as their principals take, and the oath shall be filed and entered on the minutes of the same office with the same endorsement thereof. And so here's the end note, adopted by defendants Latham, Schaefer, and Smith. So these guys all went in on it too. The court appreciates defendant Cheesebro's recognition that he filed this motion outside the case scheduling order deadline, but will allow an exception and address the merits due to the representation that he only recently obtained the necessary records and because the motion is so easily dispatched. So there's our first hot burn, okay? So this judge, oh my God, he's cracking me up. So this judge said, first of all, you're outside of the time limit, so your motion is untimely. But because it's so ridiculous, I'll go ahead and address it because it's only going to take me a minute. Cracking up. Oh, it cracks me up. I love it. So here we go. And then we've got a case here holding that the assistant district attorneys are considered deputies, requiring the same oath as the district attorney. First, the motion fails to establish that this code section is even relevant to Special ADA Wade. Explicitly, the requirements shall not apply to any deputy who may be employed in particular cases only. So he's citing case law here, recognizing that deputies sworn in for a more limited role are exempted from having to file and enter the record of their oath. So what he's saying is, according to the law, special ADAs don't need to take an oath. That's what the judge is saying here. All right. As the motion itself proffers, the district attorney's office hired Special ADA Wade for the purpose of assisting the special purpose grand jury in prosecuting the matter that led to the indictment in this case. He does not appear to have given a general assignment of any kind. Let me just make sure I'm in frame again, everybody. I kind of moved everything a little bit. Yeah, oath is not required. And he was pulled in all the way back with the special grand jury. So originally, Cheesebro was saying anything he did with the special grand jury should be thrown out too because he hadn't had the oath. To the right? Okay, here we go. How's that? Yeah, the sass is real. The sass is real. All right, how's this? Is this better, everybody? Let me just double check. More to the right. Okay, perfect. Am I good? Am I good? Okay. Thank you, everybody. All right. He does not appear to have been given a general assignment of any kind. Defendant's motion recognizes this exception, but then blithely moves on without adequately explaining why it should not apply or why this exception would not prevail as the more specific statute over any other statutory provisions referencing a deputy's oath. Here he's citing case law. The canon of construction that a more specific statute prevails over a general statute resolves any ambiguity between the two statutes. So the judge just said that in Cheesebro's motion on this oath, he had put a note in saying he realizes that he didn't have to take an oath, but didn't explain it further. So the judge is calling him out on that. Like, you even put in your motion, you know he doesn't have to take an oath. So even assuming Special ADA Wade has not been employed to handle particular cases only, this section of the code provides that the official acts of an officer shall be valid regardless of his omission to take and file the oath, except in cases where so specially declared. One might think distinguishing this safe harbor provision would be central to the defendant's argument. One would be wrong. Okay. All right, so he's coming back after the judge speak. Yeah, sorry, it's a lot. All right, so the safe harbor provision again, just stating that he doesn't have a specific case that he was told he needed to do, so the oath wasn't important. But the defendants didn't even rely on that. The defendant's citation is tucked away in a footnote with only the unsupported assertion that prosecuting a criminal case is one such specially declared situation. The court has not been provided nor located any authority to support this claim. This section of the code echoes the de facto officer theory recognized early in our Supreme Court's existence. And this is an 1856 case. An officer de facto is said to be one who exercises the duties of an office under color of appointment or election to that office. The validity of a de facto officer's acts is so well settled that it embodied the part of the code 45-21. The acts of a person ineligible to hold public office shall be valid as the acts of an officer de facto. So he's quoting case law saying again, because he's specially appointed in this particular situation, again, that oath is not required. He's still an officer assigned to this situation without having to take an oath. So the oath is not going to break his responsibility. He's also saying too, as he goes on here, that even if he did have to take an oath, which the judge doesn't believe he needs to, it would not be a reversible error. It would not be it's a harmless error that can be remedied immediately if needed, but he doesn't believe it needs to be. So that's how this is turning out. It is without dispute that Tolles was acting as deputy sheriff, at least de facto, when he made the arrest. That being the case, the arrest was legal insofar as the effect on the defendant is concerned. Despite the lack of filing, Special ADA Wade's acts while in office would nevertheless be valid as a de facto officer. So he is, in fact, an officer of the court. So this is my favorite part here. Let me move my chair around because this is my favorite part. We got to get in on this one. As if this parrot of emotion is somehow not yet dead. The defendant has failed to establish how Special ADA Wade's actions resulted in prejudice. So let me break this down for you. He's making a reference to a Monty Python skit, all right? And it's called the Dead Parrot skit. Is anyone familiar with it? I'm not sure if people who are familiar with it. I know. All right. All right, so let me explain the parrot skit. In Monty Python, right, so really funny British comedy, there's a skit where there's a pet owner and John Cleese comes back with a parrot that's dead and says, I want a refund. The parrot is dead. And the owner of the pet shop says, no, the parrot's not dead. He's just resting. And then John Cleese is saying, no, it is actually dead. And then starts throwing it around the shop and showing that the parrot's dead. And the shop owner says, no, you've just stunned him. You've just scared him. And then John Cleese says, well, you nailed his feet to the cage. That's the only reason he was standing up. And then the pet owner shop again was just like, nope, he's still alive. And there's clearly this dead parrot on the counter. All right. So this is the skit he's referencing. Many of you may be more familiar with the end of that skit where the pet shop owner says, I never wanted to own a pet shop, runs into the forest and starts singing about being a lumberjack. But that part's not really relevant to this motion. All right, so if you're a dork, if you're an absolute dork like me, you would know I'm a lumberjack. I'm not going to sing it, but oh my gosh, the lumberjack song is hilarious. All right. But I digress. The lumberjack's not relevant here. It's the parrot that's relevant. So this judge is saying explanations. Well, not many people would know that, but okay. So what this judge is saying is this parrot, so this motion, this defense counsel's motion is basically the pet store owner. So the judge is like, look, the parrot's dead. And then defense counsel is saying like, no, it's not. It's still alive. It's just sleeping. So that's what he's referring to here. And if this parrot of emotion is somehow not yet dead, oh my gosh, it cracks me up. The defendant has failed to establish how Special ADA Wade's actions resulted in prejudice. So he's saying even if the parrot somehow was still alive, so even if he was supposed to take an oath, it doesn't matter. There was no prejudice involved. How his assignment single-handedly changed any specific actions taken during the investigation or resulted in the true bill of indictment. And he's quoting case law here. Nor has defendant established a constitutional violation or a structural defect in the grand jury process sufficient to justify outright dismissal. Citing case law here, unless expressly authorized by statute, dismissal of an indictment generally cannot be imposed absent a violation of a constitutional right or when the structural protections of the grand jury have been compromised. So dismissal of an indictment is an extreme sanction. The motion is denied. Oh my gosh, this judge. This judge is so funny. Right, so he's basically saying, even if the parrot's not dead, it didn't prejudice your case, so you're done. I'm not dismissing the indictment. So he's asked for the indictment to be dismissed over and over and over again. He's asked for demur, which will be argued in the next couple of days. He's asked for all of these special treatments, special things that he wants. And then now he's even saying, wait, hold on. The special ADA wasn't given an oath. And so you've got to dismiss the indictment now. And the judge is like, no, I'm not going to do that. What's wrong with you? Yeah, this judge is pretty funny, actually. This judge is really funny. Check the parrot, see if it's still dead. Well, that's exactly what happens. He's literally throwing the parrot around the shop, and he's like, it's not dead, it's stunned. He is special. He is special. He's actually, he's a very interesting young judge, and Just very funny. So I like his sense of humor, and then the motion to dismiss is denied again. So this one is denied. So that's the update on those orders, but I do want to kind of explain a little bit this whole striking situation where he's asking for more strikes. So I'll kind of explain that a little bit more. Oh my gosh. If he uses Mel Brooks, then we know it's bad. I know. I know. Yes, yes. It's pretty funny. Oh, hydrate. Yes, I do need to. Judge McAfee is his name. Yep, yep. He's funny. He's a funny guy. I can appreciate the humor because this judge just works so hard. His caseload is just ridiculous, but he works so hard. So I can appreciate that. All right. Mel Brooks was very ahead of his time. I agree, Ava. I agree completely. Hilarious. Monty Python forever. All right. So let's talk for just a little bit here about the process of choosing a jury. Okay. So is a lumberjack cutting trees still? That's a good question. I don't think so, but there are Mounties singing in the video. I mean, it's funny. You got to look up the parrot skit. If you look it up, you'll see the lumberjack song. It's worth it. It's worth it, everybody. Oh my gosh, it's really funny. All right, so let's talk a little bit about how we go through the voir dire process. So I've just printed out a few examples again. All right, this one is out of Alabama. And it kind of talks about this process of peremptory jury strikes for the plaintiff. Here in Alabama, a 7-person jury will be selected from the first 15 jurors remaining after challenges for cause are granted. So we've got two types of strikes. We've got the peremptory strikes, all right? So preemptory strikes, and then we have strikes for cause. Strikes for cause do not count against either side. Those are strikes that the judge says, hey, there's you just absolutely are not appropriate, so you're out. Yeah, just Alabama as an example. They've just got a good sheet. So this is the strikes for cause the judge does, but peremptory strikes count against each side. All right, so the first 15 jurors, so what they do then in Alabama for this kind of a case this form is for, is that they have like 25 people originally, and several of them get struck for cause, and so only 15 are left. Now each side then has to bump it down, gets a certain number of strikes until 7 people are left, all right? So after the first 7 of those jurors is not struck by either party, it'll constitute the jury. So the process of choosing a jury is a process of elimination. So rather than actively saying, wow, this person's really good, I really want to choose them, what we do is we get rid of the people we don't want. So it's a process of elimination, and that's what we use our strikes for. So let me show you this chart. And some of you may have been with me long enough to remember when we did some jury analysis in the past, when we went through this chart. It is. And it depends on your jurisdiction, how big the jury is and how many strikes you get. So here, what he was saying was that there are 9 strikes each. So the defendants get 9 strikes, and then the state gets 9 strikes. So if we've got a 12-person jury, all right, plus, I don't know, 2 alternates. I'm not 100% on these numbers in Georgia, but I'll just show you the numbers to kind of give you an idea. So we need a total of 16 people, all right? So, all right, this is mathing, everybody. Forgive me for a minute. Forgive me here. So I believe, okay, wait. So, 15, so it's 35 people, right? All right, so which matches my chart, so that's comforting. I appreciate that. So we would start here. All right, and I'm giving you an example. So we need a total then of, how many did I say? 35. 35. We need a total of 35 people. All right, so let me just kind of fill in the boxes here. I'll take a look at everyone and just kind of pull some names in to fill out the jury chart. This is literally how we do it, and I'll show you how the strikes work. So let's see. Okay, Desert Skies is one. Desert Skies here. And Frank, we have number 2. We have Selena here. Mary for number 4. So again, these would be all the people in the pool. Jilly, that would be pulled into the box, okay? And then Jen would be next. And then we would start our next row. This is literally how we do it. Ernest, okay, Ernest. And then I think I saw, hold on, I saw Stacy here. I saw, Lisa, sorry everybody, I'm trying to catch up. Blondezilla, Blondezilla, here we go. We got Ellie. We've got Ava. Let's see who else. Polly here. Funk Whistle. We'll just call you Funk, okay? Mr. Incognito. Oh my gosh. Luke, all right. Luke, you're number 15. Ines here. We have Deb here. All right. So we're only at 13, or we're only at 18. I need a few more. We've got Mads in here. Let's see who else we have. Dark S Bear. Dark S Bear. Oh my gosh. I love it. Okay. Ringo, I've got Hilltop, let's see, Matthew. Okay, now we're flipping, so let's come back over here. So I'm gonna continue to fill up my chart here, all right? So actually, I printed this twice so that I can just make 2 sides. So let me do it this way. Matthew here, and then I saw Becky, Amanda, you're number 25. Melly, you're in here, okay. Juanita, I hope everybody's ready to be part of the jury, right? Rain Hats, all right. How many people volunteering for jury duty? I know. Thanks, everybody, for coming in. You get your $12 for your day's worth of work. Heidi, Linker, okay. Let's see, Climate, I'll put you in. I'll just call you Climate, all right? Gina, all right. I still need a few more. We've got John, okay. John, I'm not impartial. Well, it's good you can recognize that. And then Kelly, all right. So here we go. We've got our chart, everybody. Thank you so much for everyone that volunteered. All right, I appreciate it. So this is what our jury chart would look like, all right? So let me make sure I've got my, my page set up here. So we're starting all the way down at the bottom here with number 1, all right? So these are the ones that have been called in. Typically, the clerk will just randomly choose numbers and then call in, we'll say 35 here, which is the number that I'm kind of crunching here. Let me make sure I've got this correct. Right. So I need a 12-person juror and 2 alternates. So ultimately, we need to get down to 12 people and then 2 alternates. So we'll originally go for our 12-person juror. So that means each side gets 9 strikes. They can't pick a jury quickly. Will it go past speedy deadline? No, this judge will have them chosen. I have no doubt this judge will make that happen. Guilty. All right. So at this point, let me just do some random questions and I'll just kind of show you how I would mark this up, all right? So just to give you some idea. So the government is green, the defendants are orange, and then pink is going to be for neutral. So typically this is how I would do it. I would go through and I would ask a few questions. So I'll just ask some general questions here in order to illustrate how the questioning process works. So if your name is on the chart, make sure to answer my question, okay? If you could. So here's you move to strike yourself. Oh my gosh, that's so funny. All right, so here's the first question that I would ask. And I actually got voir dire questionnaire, very, very generic here. So I'll just go ahead and ask these questions just to keep everything as extremely neutral as possible. All right, so the first question here, and again, you know, everyone's been sworn in. So I would say, okay, if anyone here in the box, Climate keeps pinching me, Climate, Climate, come on. So my first question would be, does anyone here have a personal relationship with Mr. Cheesebro? Anybody? Can you please raise your hand if you have a personal relationship with Mr. Cheesebro? Anybody? No. Lisa? No. 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 Nope. Okay. Excellent. Excellent. No, we don't. No, we're vegans. Blondzilla does. Okay, Blondzilla. So my question, Blondzilla, if you're out there, do you think your personal relationship with Cheesebro would keep you from being able to be fair and impartial? That would be my follow-up question. All right. Please define personal. Right. So you have a friendly relationship. He's someone on your Christmas card list or someone you would invite to your kid's high school graduation. Right. I had to answer. No problem. I've been on a date with him, but he didn't pay. Okay, yeah. So that would be very well to know. Yes. Okay. So Blondzilla is the only one. We'll just use this as an example. It's okay if she's gone. We'll just use this as an example then. So I've put a star for defendants next to her name just to keep that in mind. So my next question would be, is anyone familiar with Fani Willis? Is anyone here gone to Miss Willis's home and had dinner with her and her family? Anyone here who knows Miss Fani? Okay, Frank. You said you know Miss Fani, all right. Anyone else? No, nope. Anyone else? No Miss Fani Willis. Miss Fani Willis at all? She's the district attorney. Okay, Michelle, your cousin used to work with her. Okay. Do you think that would have any kind of an impact on how you would be able to decide this case at all? No? Okay, excellent. So we'll just say Luke. I'm losing track of everybody's name here. Okay, so Luke, you did too. All right, and everybody feels that you could still be impartial with that. Okay, excellent. The next question is, does anyone here feel like the media is completely evil? Anyone feel like the media is evil and should not have freedom of the press? Anyone at all? Yes, no, sure, no, okay. So we've got no, it's not evil. Okay, let me see. I'm gonna just try to catch everybody here. All right, Deb, I saw you here. Okay, Deb. Fox does, okay, absolutely. All right, Fox. All right, so I'm just gonna put some stars on here, okay? I can't keep up with y'all. But let's just say these are for all of the people who felt that the media is okay, all right? So I would make a note and I would say the media is okay, so they're not against the media. So that's a neutral question, all right? Now another question that I would ask would say, does anyone here believe that it's okay for anyone to get voter registration information? Anyone think that everyone should have access to private voter information? Anyone at all? Everyone should have access. Who believes everyone should have access to private voter information? Okay, Frank, you say no. All right. No. Deb, you also say no. All right. So Deb's a no. Dark is a no. Becky is a yes. All right, let me find you here, Becky. I'm gonna look for Becky. Becky is a yes. Amanda, no. Mike. All right, so I'll just kind of mark these off So who is saying yes here, and then who is saying no? So the ones that are saying no to voter information, I'm marking with a color for the government. The ones that are saying yes, I'm marking for Miss Powell, all right? If you're not on the jury, resist the urge to answer. No, it's okay. It's funny. It's funny. All right, all right. So my other question would be to everyone. Has anyone here been following this case that's been going on in Fulton County about the RICO charges? Has anyone been watching everything that's been going on the news? Anyone who is constantly following this case? Anyone? Yes, yes. Okay, Selena. Oops, here we go. Selena, not at all, not at all. Okay, Frank. Strike. No, no. Mr. Incognito is no. All right. Ellie will say is no. Yes. Yes. Okay, I've got to switch you then. Oh, yes. All right. Ringo watched the TikTok attorney. Okay. All right, so we'll put him in favor here. Oh my goodness, there's some pants on fire. True, true. So those kinds of questions, if you are watching it, all right, so we're going to kind of, again, note who's watching it, who's been keeping an eye on it, who doesn't think the media is bad, who knows the defendant, who thinks voter information should be allowed for everybody. So all of these kinds of questions, then I would put different information next to, okay, at this point. I'm in love with Miss Powell. Okay, Frank, we got you. We got you here. So that's a big one for you. Oh, that's a big one for you. Jen's been watching. Okay, so Jen's been watching. So let me add some information. Hold on here. I've got to find you, Jen. Here we go. So Jen, I'll just put a W there. So whenever I'm asking these questions, I would just make a note on who answered. All right, who answered, who didn't answer. One more question, everybody. This will be my final question, and then I'll take you through the process of striking the jurors. So one last question. If the judge was to tell you that you need to just focus on the facts that we give you and the information and evidence we show you, would you be able to just focus on that? Or would you look at outside information? Would you only focus on what the judge said, or would you be looking at outside information in order to validate it? Yes, yes, easily, absolutely. You could focus, you could focus. Okay, Frank is a maybe, all right. Focus, okay, you'd be able to focus. Yes, Stacy would as well, all right. So Stacy would, no, I'm ADD, Katrina. That's so funny. Fair enough, fair enough. Focus, yes, yes, Amanda. All right, so for anyone who says yes, I'm going to put a red dot, all right? For anyone that says no, again, I'm just kind of showing the chart here, everybody. I can't keep track of who it would be. No, 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 no. Ernest, yes, yes for Ernest. Blondzilla is a yes, yes, yes. Focusing. Okay, can I look information up on Facebook? All right, what's your name again, Taylor? Wherever you would be, Taylor, this would be you right now. No, I'm just kidding. I'm just kidding. Sorry about that. Oh, all right. Gina, yes. Okay, excellent, excellent. Yes, and yes for Becky also. So let me make sure I get Becky in here. Yes, yes. Heidi is a no. Okay, so let me just make sure I have everybody. Okay, what about Julie and Mary? Yes or no? Julie and Melly. Let me pull Melly in. Melly's a yes. No. Deb was a no. Yes. Okay. Everybody. I'm sorry if I mark it incorrectly. Okay. I'm just, oh my gosh, it's getting away from me. This show's getting away. Oh my gosh. Okay. And then one more here, and then we'll go ahead and do the strikes. Okay. Here's Linker. Oh my gosh. That's so funny. Okay. Okay, everybody. Matt said yes. All right. So the point is I've made up my questions. I've asked my questions. And so now it's time to go through and do my strikes. Now, remember, we have 35 people because everyone else had already been eliminated. So we need to pick 12 people plus 2 alternates. Because of that, we have 9 strikes. All right. So the first person that goes will be the government. So the government will take a look at their chart. Now, anyone that has a green mark is one that looks favorable to the government, has said something that, they have been keeping up on the case. They have some knowledge of the case, so that could be good. So what we don't want is someone who is extremely favorable to the defendant at this point. So let's just say, for sake of argument, Ines is the one that knows Mr. Cheesebro personally, all right? So we would do this. State has done strike 1. So then next, we would have the defense counsel. They would come up and they would look and they would say, all right, well, Ellie thinks that Tay thinks that the media is okay, is also watching it, is also not going to be biased, so we want to get rid of her. Okay, I'm just hypothetical. So defense has done 1 strike. So we have 1 strike for defense, 1 strike for the state. Okay, so then I'll go ahead back as the state and take a look, and we'll say, you know what, I don't think Gina is going to be favorable for us. State's 2nd strike. So then we move on. Defense comes in and says, well, Luke seemed to be pretty open-minded. So I'm just kidding. 2nd strike for defense counsel. All right. So then next they come in and they say, let's see, Ava seemed pretty good. Let's keep her. Susan didn't have much to say other than she could follow the rules. Amanda looks like she'll be helpful here. But we do have Frank, and Frank seems to have this relationship with Miss Powell. So we're going to go ahead and strike Frank, state's 3rd strike. That takes us to defense, and they're going to say Amanda seems pretty fair and impartial. So we're going to strike Amanda, defense 3rd strike. Next, we've got Blonzilla. We're not really sure about her. So there's the state's 4th strike. Climate, sorry about that. Defense's 4th strike. Next we have Mads. We're not really sure. She seemed like she wasn't necessarily going to be completely impartial. So we're going to need another strike there. Thunk, we're just not sure about either. So there's the 5th strike for defense counsel. Now we have Susan. She said she could be fair and impartial, but we're just not sure. We get this feeling that she may know something about somebody. So there's the 6th strike. Defense comes in as well and says, Melly, you look like you could be fair and impartial. No, I'm just kidding. No, Melly, looks like you have a very negative opinion of the defendants that came out during questioning. So now we're back here. Selena, sorry about that, but you'll be struck too. So we've got 1, 2, 3, 4, 5, 6, 7 strikes for the state. And we've got Rain Hat here. So we've got 7 strikes for defense. So let me just double check my numbers. So we get 2 more strikes each. So now we've got only a few people left. The state has 2 strikes left. Defense counsel has 2 strikes left. So the first thing the state will take a look at then, because it's the state's turn, is they'll take a look and they'll say, anyone who's left, do they have any kind of positive lean towards the other side? So we have Becky, she does. So we're going to strike Becky. All right, so there's number 8. Then defense counsel is going to say, which one do we feel will absolutely be on the state's side or will not be able to put aside their feelings in order to go forward? We'll put it here and we'll strike 1 more. So each person has 1 more strike left. Again, we've got 1 last person who's got this orange tick, which again just notes that there's some kind of a positive spin for the other side. So we'll check that. That's number 9. And then the very last person here we have is Ringo. We think Ringo might be a little bit too much excited about the government's case. So everyone has had 9 strikes, all right? 9 strikes each. So our jury then, here is our jury. Ms. Kelly, Mr. Matthew, Ms. Linker, Heidi, Juanita is part of the jury. John, you're part of the jury. Hilltop, you are part of the jury. Dark Bear, you are on the jury. Ava on the jury. Jilly on the jury. Mary, you are there. Mr. Incognito. Lisa on the jury. Stacy also on the jury. Ernest on the jury. Deb and Desert Skies, you're the last two chosen, so you will be our alternates. Okay, alternate 1 and alternate 2. So there's our jury. All right, there's how our jury is selected. We eliminated 9 for defense, 9 for the state. Then we had 14 left. The last 2 are the alternates. This is rigged. Well, I mean, it's kind of quick and dirty, everybody. I mean, the voir dire questions are going to be a lot better than that. But that's how we do it. That's how we do it. Now, we don't always just have, pen and paper because, we're not horse and carriages here. We're more advanced than that. But our program will take us through and we will set out our chart with our number of people in the boxes where through a process of elimination, what happens are the ones left that we don't dismiss, that is our jury. That's the process of voir dire. You got mega crossed out. Hey. Oh, that's so funny. You think 9 strikes is appropriate? I mean, that's what Georgia had set. What Cheesebro is saying is that because there's 2 defendants with 9 strikes, they get 4.5 strikes each. So they'll have to talk to each other during this process in order to combine their efforts to strike the jurors that they really don't want. Sometimes it's really obvious. Sometimes you can make a note like this one's definitely going to be for the government. This one's definitely going to be for defense. And if you see those, you can start with them. You start with the easy eliminated ones. But then after that, it gets more complicated. And sometimes the jurors that get chosen are the ones that just didn't have anything really to say one way or the other. So that's, again, that level of impartiality. How many questions would be asked in a case like this? A lot. That's why Cheesebro was asking for more time. The judge had said, I think, 1 hour per juror, I think is how he had put it, per attorney, I think, or for each batch, each batch of 30. I can't remember exactly the number, but he was giving them this 1 hour time period, which seems like plenty, but he'll have an idea then. This is a runaway jury. How much do you study the jury's life? So that's a great question. Before we even sit down, right? Before we sit down to go through these strikes, I would know that all of these people would be on my list. There would also be another 25 people, okay? I would get a stack of information on names, and here's an example. Name, where they live, how long they've lived there, what their marital status is, their occupation, employer, where they're employed now. So this basic information with their name and address, I would get all of this before we sat down for voir dire. So I could then go out and do my own research. So if I've got, let's just say here, I've got Jilly Jen, all right? So Jilly Jen, and she's filled out her questionnaire. And so I go online now. I could go to her social media if I wanted to, if I've got time or someone in my office, and I could pull up her social media account and I would just take a look through and I would be, what I would look for, this isn't how everybody does it, but what I look for, are there any pictures of her with the defendant? Are there any pictures of her with anyone in the government's office? Are there any pictures of her, at the Capitol on January 6th? What's going on? So I would take a look and see in general what that information was. Now, the details of where she went, who she was with, all of those kinds of things aren't necessarily relevant to me. I want to know if she's got a personal interest in the case, because that is where I would ask the judge to strike for cause. So that's why I would use and in the past, why I would do any research was, again, just to make sure that when I'm asking her questions. So let's say that Jilly then is now being asked questions. And so I would say, so Jilly, do you have social media accounts? No, I don't. And I would immediately say, I think I saw you on Facebook. And she would say, oops, I'm sorry, I forgot. those kinds of things. So now I'm questioning, is she going to be able to be honest, or is she nervous? What's going on? That could take me down another road of questioning. Is there a book deal in this? I don't know. I don't know. I would imagine so. I would imagine there would be book deals. So this is just kind of a really rough view. I did find another chart that is much more organized than what I have. And this is, again, we've got jurors 1 through 40, and then they would do the same thing. They would write everybody's name down, but then they actually have a key that they use. So if it's an A, they would check here. They accept this juror. Or if they want to strike for cause, they would hit S. Or if they absolutely wanted to reject number 21, they would strike there. And then just generally at the very bottom, they have checks and X's. So number 35, in general, I get a bad feeling from him. Or number 13, I get a really good feeling from her. Or number 10, I don't know, they didn't really say anything I didn't like, but I'm just not sure. So that's how this chart works. So they actually have this set out with a specific key. So I like them. I'm going to ask the judge to strike for cause. I'm rejecting them. I feel good or I feel bad about each individual one. So this is just another example of a chart you could use during that process. Can you run credit reports and other investigative type steps on them? They are limited. I've never heard of credit reports being run. If there's any information that anyone in the public has open access to, all of that information is available for anyone. But for people, there's only special access for like criminal records. You have to have special permission to pull criminal records. So if you don't have that kind of access, you can't do it for your potential jurors either. So when I'm saying research, I'm saying whatever is open and available to the public. The only caveat I would say with that to everyone is that I would say people don't realize how much of their personal information is online. And all of that public information is available to anyone, including people looking at them to choose them for jurors. This is one of the problems that's going on in the DC case right now, is because instead of just doing this list of people, they're going and they're knocking door to door, asking questions about how they feel about the situation in DC. So that was one of the questions that Jack brought up, saying you need to get your methods approved by the court before you go out and do that. Can the judge overrule the lawyers? I'm not sure what you mean, Becky. The judge can strike for cause, meaning make a determination. Like if we had, let's just say we've got Bob and Joe and Billy. All right, these guys are extra here. And so Bob is like, I hate the government. I hate the government. I hate you. I hate your dog. I hate your family. So I would say, Your Honor, objection, we strike for cause. And so the judge would say, now, Bob, just because you hate the government, does that mean you can't be fair and impartial? And then Bob would say, no, I would rather, go and drink a vat of pudding than, be on this jury. I hate everybody. And so the judge would say, okay, Bob, you can leave. You're struck for cause. All right, so that's really the judge's role in striking here. The other role the judge would play with the peremptory strikes, which is what these strikes are called, is if there's a question, we only struck this person because of race or gender. So the judge would ask the attorney, what were the reasons why you struck this particular juror? And we would say, well, because they said that they knew the defendant, or because they said they worked in the government's office 10 years ago. As long as it's not based off of race or gender, you're okay. But the judge does need to assess that. What did my dog do? Well, a vat of pudding might be too much. I don't know. I just, Bob loves pudding. I'm sorry, everybody. Sometimes my hypotheticals go off the rails a bit. They never admit the real issue. They know better. Well, that's a question that is debated in the legal field when it comes to reasons why people are struck from juries. And again, we've got Batson v. Kentucky, that's race. And then we have the JEB case on peremptory strikes and gender. Those cases are good law from the U.S. Supreme Court, and you can argue it. And it is something that is an ongoing debate in the legal community. But typically the judges will say, as long as there are other reasons, then, we're good to go. But if they do find blatant issues with race or gender, then there could be a serious problem. Can the defense ask who the jury panel voted for in the presidential election? No, they cannot. They cannot ask that. Now, if I was to pull up someone's social media account, all right, so let's just use Linker as an example. I'll pick on you for a minute. If I was to just pull this up, because for some reason, after Linker filled out the jury questionnaire, I thought, wait a minute, are they saying that their cousin is related to the defendant's uncle? So I might check on their social media and see if there's any pictures of family reunions when they're hanging out. Now, if I go onto Linker's account and I see Linker involved in a ton of political activities, I will see that. It's not that I won't see it. It's posted for the public. It's out there. It's available. But I would put that aside because I'm not interested in that. I'm interested to know if there's a personal connection with the defendant. So that was my goal. And again, technically, if you have all of your campaigning photos and so on up on your social media and it's available to the public, then yeah, the potential attorneys and the potential jurors, they could see that. But can they specifically ask you that? No. All they can ask you is, do you think anything in your world would make it so you could not rule fully impartially on this case? You could not look at the facts, take the judge's instructions into accord, and make an impartial decision. Yep. They're registered to a party. You pretty much know that's public record. It's true, it's public record, but typically, at least in my jurisdiction, that was never and is never something that we look up. That would be something, again, there's ethical questions involved too, ethical limits for an attorney. Personally, I would never look up someone's political party. And there are many attorneys like me that would not do that. It just would not be appropriate ethically. Because also you can be registered to one party, but, always vote for the other party. So, party registration does not necessarily reflect accurate political ideology either. So there's lots of questions about that. But that's not something I would look up. I would not look up credit history. I would not look up a criminal record. I would not look up political association. Typically, what I'm going to be looking for when I'm doing research is some kind of a link between these people and my case. So they somehow know somebody. Like, let's say Juanita here went to school with Clark's daughter. And so they're best friends and they're roommates. And I found that out on one of the social media apps. That could be a conflict. So now I'm going to wonder if Juanita is appropriate because I saw some posts with her and Mr. Clark's daughter, as best friends or roommates. Those are the kinds of things that we would typically be looking for, those kinds of conflicts. Yep, need a warning. Sorry, Frank. Oh, that's so funny. All right. So that gives you some idea, okay, again, kind of a quick and dirty way of looking at it, of how we go through this process of choosing a jury. It is a process of elimination. We go through, we ask our questions. Most people are much more organized than kind of my bit of disaster here. But we put everyone's name into our chart that we have for our original panel. Then we go through, we ask questions, then we add our thoughts to it. They're good. We've got a good feeling. We got a bad feeling. We want to accept them. They said something that really makes us think they're going to be good for being impartial or whatever. And so we make sure we make a note of that at the time, because at the end of it, we're going to forget what everyone has said. So we have to make notations like this. So when we go back through and do our strikes, we can choose like, okay, so I want to make sure that all of the accepts are chosen. All of the ones that I wanted to reject are rejected. And then that's how I determine where my strikes will be used. Pick someone else. Yes. Oh, well, thank you. Yeah. No, unless you've been through it, it's really kind of an odd situation. It's not something that can really be explained very well. The visual is better. Even a messy visual like this is easier to understand when we're talking about strikes. They are literally striking you off of the jury box. Okay. You see now where the word strike comes from. I'm striking you from the jury. So when you see that, it means I'm crossing you out. I'm eliminating you from the jury that will be sitting for the case. What about medical reasons? Would they not even be in the pool? Yes. So medical reasons, those kinds of things, all of that gets sorted out ahead of time. So anyone who's actually in the set to be questioned, all of the childcare issues, medical issues, any of those things would all be taken care of before. So these are the people that can sit in the jury, that have made all of the qualifications. Now, during the judge's hearing, when he was talking about this, he was saying we'll probably find maybe 5 a day is what he was saying. And what he meant by that was they'll be asking questions of 100, and maybe out of 100, only 5 of those would be appropriate to set into the original set of boxes. And so it'll take multiple days in order to get your 35 count, to get enough people to ask so that we can eliminate enough to get the jury number we need. Yep. Oh yeah, sure. 5 juries and a foreman twice. Oh my gosh, you're doing your civic duty. If you're pregnant, can you be excused? It will depend. It will depend on the situation. I think that there are some people who are pregnant who would be absolutely fine serving on a jury. But if you have a really bad pregnancy, or you've got other concerns going on where you don't think it would, health-wise, it wouldn't be the best, you can tell the judge about that. But is just the fact that you're pregnant enough to get you off of the jury? I would say no, not in and of itself. You would need other reasons to support removal from that. Can I be excused? Need to feed your dead parrot. Matthew, you can't feed your dead parrot. That's so funny. Oh my gosh. Yes, bathroom breaks, yes, but it's possible. It's possible. And, accommodations can be made for any kind of disabilities. And, it'll depend on your jurisdiction, but judges and attorneys, we try to be understanding about that. If there's a disability, if there's a hearing disability or a visual disability, one of the big questions that I would always ask, does anyone have any kind of a medical issue that would keep you from being able to sit for a long period of time? Because sometimes there are physical medical conditions people have where they just can't sit. They literally can't sit in the jury box and listen, for 8 hours. And so I always thought that that was something that was important to kind of make a note of that. Who would be able to sit still for that long? What if you have a criminal record? If you have a criminal record, that would be disclosed typically in that original questionnaire. There would be a question on there. Have you and your family ever made a claim for personal injuries? There would be a question that would say, have you ever been arrested for a serious crime? So that would be in the questionnaire. We would take care of that right out in the beginning of it. You're tired, you want to sit on a grand jury? Yeah, it could be interesting. I forgot everything they said. Yeah, that happens a lot. It happens a lot. Oh my gosh, preemptive disqualifications for 3rd trimester pregnancy. Oh, that's great. Oh, love it. Love it. Oh, hydrate. Absolutely. I'm glad to hear that. I mean, yeah, if you're in your 3rd trimester, I don't know. I'm sure some women are like, whatever, who cares? But my 3rd trimester, if it would have been me, oh my gosh, no way. Nope, there are plenty of women out there where they would have been like, nope, no thanks. Nope, that 3rd trimester, no way. Do you know if voir dire would be televised? No, it won't be, because there's a lot of really personal information. You have your link tree in the profile, but it won't link. Oh, bummer. Yeah, no, the voir dire process, because it's all such personal information with everybody's name and asking questions like, do you know the defendant? And someone would say, yeah, I went on a date with them. And, like Hilltop was like, yeah, we're whatever. I had dinner with, the defendant's parrot or whatever. then you would follow up with questions on that. And you don't want any of that information kind of out in public. So it's private. It's handled pretty privately. What if you cannot be sworn in? So, Tay, I'm glad you asked that question. So the rule, the legal rule is you have to swear or affirm that you'll tell the truth. It doesn't mean you have to swear to some kind of an entity. That is old school. We don't do that anymore. You just have to, it's your word of honor. So you would hold up your hand, you swear or affirm you're about to tell the truth. Answer the questions truthfully, yes, so that's all you need. You don't need to have any kind of a faith or a religious belief whatsoever. You just would swear to tell the truth, and that's all that's needed. In places where they still do use maybe a religious element, they're not in compliance with the law. Now, we have to kind of pick our battles, and so if there are courtrooms that still do that, it's up to each individual courtroom if someone wants to go and fight it. But they're not supposed to under the law. Legally, you're not supposed to bring that into the courtroom anymore. On your very alive parrot. Yes, exactly. That could be plenty. Can we pull the jury now for a verdict? Okay, everybody. So have we decided? Is the defendants guilty? Did Mr. Cheesebro and Miss Powell commit the RICO charge? Everybody? Guilty? Who's guilty? Guilty, not guilty? Guilty? Guilty. Okay. Guilty. Yep, guilty. Okay. Oh my goodness. Okay, it's not looking good for the defendants here, everybody. It's not looking good. Oh my goodness. Undecided. Fair enough, Lisa. Fair enough. We need more information. Has it to be unanimous? Yes, in a criminal trial, we have to have a unanimous verdict. Oh, thank you. Yay. I guess, is that for the verdict? I didn't hear any evidence of the innocent. Fair enough. No more cheeseburgers. Oh my gosh, y'all are cracking me up. That's so funny. Trying for a hung jury. No. No, we don't want that. No. That's every attorney's worst nightmare. We wake up screaming. Trial attorneys, I tell you, we literally wake up screaming in the middle of the night. Everybody has that dream that they accidentally, went to school and they missed the exam, right? Everyone has that dream. For trial attorneys, it's that we have a hung jury. That's our absolute worst. Or that we've somehow said something to the jury that's prejudiced them, and then the whole case gets tossed out. We just absolutely have a nightmare about that. We don't want that. Nope. How is the foreman decided? It depends on your jurisdiction. They'll set out the rules depending on which state you're in and which jurisdiction you're in on how they go about choosing the foreman. So it really will change depending on where you're at. Typically, we have the jurors will elect essentially their foreman, the person that they think is the most appropriate, but that's not always the case. So it will depend. Mr. Cheeseburger. That's so funny. Oh, yes, Mr. Cheeseburger. When are the jurors told which case they'll be on? So at the very beginning, in Georgia, based off of what I've heard this judge say, they will give a little synopsis at the beginning before they start the voir dire questions, explaining a little bit about the case, with everything being pre-approved. He will not be reading the indictment. He will give a little summary of what the case is about before they're asked the voir dire questions. So that's when they'll first have an idea of what the case is truly about. Whoever draws the short straw gets the foreman. Yeah. Oh, good night, Deborah. Good night. Thanks for coming tonight. Always appreciative of your time. How many times can they retry with a hung jury? Well, legally, I think you can just keep retrying it. But, as far as your ability to pay for the trial goes, or how far the government's going to, how many times they're willing to pay, trials are extremely expensive. And also the emotional and mental anguish and difficulties that it takes. Trials are exhausting. Criminal trials are absolutely exhausting. They completely consume your life. And when you put every single ounce of everything you have into a criminal trial and it comes back with a hung jury, at the very end of that, you might think, all right, we'll try it again. But if it happens again, a lot of attorneys are like, tag me out. I'm out. I'm out. I'm done. I'm not even going to do criminal work anymore if you come back with 2 hung juries. So technically you could probably keep going, but would it actually happen more than twice? I just don't know. It would have to take a really special case. Can being an attorney pardon you as a juror? Technically, no. If we go in as attorneys, we fill out the form and we say we're an attorney, and depending on your jurisdiction, you probably know the attorneys that are trying the case if it's a smaller jurisdiction. But if you're in a huge jurisdiction, you may not. But yeah, you make it known. But we are usually not chosen for a jury because our goal when we choose a jury is to get a nice impartial panel. But if you put an attorney on there, they may try to lead. That typically happens because they'll say, I know the law, I know this and that and the other, and may have too much influence on the other jurors. And we don't want that. We want an impartial panel. So typically we do not really want to have attorneys on the jury or judges either. Judges are a little bit better because they're impartial. They can go either way, but attorneys just can tend to come in and take over. And you just don't want someone that's going to take over the jury. You want everyone to kind of be able to equally have a say in what's going on. Do hung juries happen often? Not that often. I think statistically, we really just don't have that many criminal trials, honestly. I mean, I think 2% of our cases actually make it to jury trials. It might be a little bit more than that, depending on where you're at, maybe 4 to 6%, but it's a small number. So it doesn't happen that frequently. And it happens sometimes when there's a credibility issue. Typically, if the victim in a particular situation, the jury is having a hard time believing, like they want to believe the victim, but for some reason the credibility is an issue. In those kinds of cases, you can get a hung jury where ultimately they just can't decide if they believe the victim or not. So sometimes it really comes down to credibility, what they believe and what they don't believe. Can a hung jury be a blight on an attorney's credibility? Oh, I don't think so. I mean, if you have a hung jury, it's about the jury. It's not about the lawyers. If the facts and the evidence are put out in front of a jury and they just can't come to a decision on it, it just means, the strategy didn't work out. And, it's just part of the job. You go in with your strategy, you do the best you can, but, if you didn't make it, you didn't make it. And so that we don't look down on that. I think attorneys that go to trial, that try cases, automatically are such a small number that they already kind of get props just for going in and trying cases all the time. Most attorneys will never see the inside of a courtroom. That's just statistically how it is. So if an attorney actually goes in and tries a case and there's a hung jury, they still get full credit for taking a case to a jury trial. Oh yeah, my hand do talk with my hands. I do, sorry about that. I do. Do they want cops on a jury for criminal cases? I recuse myself from if possible. Yeah, we don't really want cops on our jury either. Again, though, it's because of that same kind of issue. We don't want someone to try to lead or push anyone on the jury. We don't want anyone that may come in and have some kind of, authority in the situation. We want everyone to be neutral, to be equal, so no one dominates the jury. And cops, law enforcement can do that too. I have known FBI agents who've been on juries before, so that's been okay. But your local police officers, yeah, they're not really who we're wanting on juries, again, because we don't want any one person to dominate the jury. Do they still have the attorney's record for wins? We don't really do that. We don't really keep a record. We don't. We, in our heart, I think we keep a record, but, I've done so many trials. I honestly just lost count. I lost count. I think I lost count of wins and losses, maybe around 250. And I think I've done about 500 cases, 500 trials. And, you just lose count when you do so many, if you're in court all the time. But this is in the criminal world. If you're in civil litigation, it's a different story. You're just not going to trial that much. But if you're in criminal court and you're a trial attorney trying cases all the time, you just lose count. You just do. Never been selected for jury duty. Is It's because I'm in the military. Oh, I don't know. I don't know. I don't know that military, we don't see, I mean, in general, and this again is just my opinion from the work I've done. I've never viewed military at the same level as law enforcement when it would come to trying to dominate or take over the jury. I've always found military to be more really careful about following the rules. So I've never had a problem pulling military in, but some attorneys feel like, you're working hard enough, you're doing your service to the community. You've put in your time, you've helped out your fellow citizens enough being in the military. So, we'll kind of cut you a break. So it depends, it depends. Good night. Yes, Dilly Bean, good night. Yes. Thank you for coming tonight. Appreciate it. Always good to see you. Always good to see you. Have you ever been a lawyer in a police interrogation with a client? I've not been involved in any police interrogations. Because if I have a client calling me and they're in the police station, I tell them to stop talking. So there is no interrogation. So I guess is how I would put that. I've interrogated police, but no, if I've got clients in jail and I just tell them to not talk, don't say anything, and then we go get it sorted out. And then if we've got questions, we communicate through the prosecutor. We don't go to the police themselves. Yeah, but sometimes you get a call at 2:00 in the morning. Like, should I do a PBT? Should I blow or not blow? And it's like, oh my gosh, it's 2:00 in the morning. What are you doing? Oh my gosh. You should do live commentary on the New York Court of Appeals arguments. I might do that. That would be fun. How fun was that, interrogating a cop? I guess it's not really, I don't know. Maybe I've just done it so many times that it lost its appeal. But, the whole point when you're interrogating anyone is you're trying to find what you're looking for. And so you just get really caught up in your questions and you continue to kind of dig and dig and dig and dig until you get what you need. So, it's just part of the job. It's just, that's just part of your job. We ask questions constantly. It's our job description. It could be cops. It could be criminals. It could be people in prison. It could be store owners. Whatever. It could be doctors, we just ask the questions we need to ask in order to get the elements that we need to prove. So, have you heard Hawk's story when he got jury duty and knew the judge? Oh no, that would be hilarious. That would be hilarious. Oh my gosh, I'll have to look that up. Oh my gosh. You should do a daily recap of the televised trials. Really? Yeah, maybe I could take a look at that. I recommend not talking. Well, yeah, exactly, Ava. You got it. Yeah, we just, we're like, just don't say anything. Do lawyers worry about getting on local cops' bad side? Absolutely, David. Absolutely, we do. If you upset a cop, bad things can happen for you. But on the one hand, for anybody, and I don't mean like they'll come for you, it means that they're less likely to cooperate. I would say that's true for anybody, but particularly for police, because you need them in order to do your job. So typically police officers, I've not had a lot of problems. I've always gotten along pretty well with police officers overall, but I have had a couple of incidences where I have rubbed an officer the wrong way and he has just, there's one in particular, he just screamed at me and it blew my hair back over the phone. He was so mad. But even though that happens, you don't want that to change what you need to do legally or ethically. It's just more of an annoyance. It just makes your job harder is all. That's really what it is. Yeah. Oh yeah, it happens. No, it happens. It does. And I had this situation with this one particular officer, and he was ranked higher than an officer, but I won't say what his rank was. And I called him out. He wrote a really bad police report and I called him out on it. I'm like, you totally screwed my case up. We're going to trial in 2 days. And, do you mind? Can you like write a decent report next time? I was stressed. I had trial coming up. I didn't have time to coddle this officer. And so I was like, dude, you screwed it up. And so he called me back and he's like, do you know how long I've been on the force? I've been working for decades. I've been working longer than you've been alive, blah, 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 blah. And I just put the phone down on the desk and just was listening to it vibrating the desk. And then when it stopped, I was like, I guess he's done. And I was like, okay, I'm glad we had this conversation. It's like, we're done. Ava, you know what I'm saying. Yeah. Yeah, you learn the hard way not to talk to answer questions the record does not catch. True, very true, very true. I would have hung up. Well, he needed to vent, and as long as I wasn't listening, I didn't listen and I didn't care. And so I figured it wasn't affecting me. So if this is what he needed to do, fine. But then I had other officers tell me, welcome to the club. He like yells at everybody and swears and cusses everybody out. And I was like, I didn't hear it. I don't care. Let's move on. I got stuff to do. Yes, yeah, the mute button, exactly. Easy to let it roll. Well, it is. You really have to pick what hurts you and what doesn't hurt you when you're working in criminal justice, because, if you're not careful, it will just absolutely take over your world. So you just learn over time. He may be watching right now. I doubt it. I doubt it. I've met so many, I just have to admit, I have met so many amazing police. I'm just very lucky, I guess, in my jurisdiction. The cops and the deputies that I've worked with overall, just overwhelmingly have been amazing. Have they made mistakes? Yes. Have we had problems? Yes. But they're still amazing. Sometimes the case would have to be dismissed because the cop screwed up. They get upset about it. And it's like, well, I'm sorry, you screwed the case up. I had to dismiss it. It was a bad search. Sometimes that just happens. It's just kind of part of the job. But it just happens. And you just kind of deal with it on the daily. He's been a cop that long. He should know how to write a damn report. So true, Daisy. I know. That's actually some of the first classes I started teaching were criminal justice classes, because I went in part-time teaching just to teach how to write reports, because I was so frustrated with my local law enforcement. And I was like, look, let me show you how to write a report, okay? That was decades ago. That was a long time ago. Oh my gosh. Yeah. They're human. Absolutely. Well, maybe. Oh, maybe. Yes, and I have had bad reports absolutely screw my cases up before, and it drives me crazy. Oh my gosh, it absolutely has driven me crazy. I'm having PTSD over it. But, it happens. And there's a lot of stuff that happens that's, you kind of flying by the seat of your pants when you're out in the field, and I get it. But then when I'm sitting down looking at the paperwork, I'm like, this is bologna sandwiches. In one case in particular, there was a search and there were illegal substances found during the search. And the search was so bad. I pulled the deputy in and I just looked at him and I'm like, what even is this? Like, how is this even on my desk? How did this happen to you? Why are you this way? Make it stop. And I dismissed the case. And I was like, dude, I got to dismiss the case. You totally screwed this up. Yeah, it's not perfect. We do our best. Oh my gosh. Yeah. It's like, oh my gosh. I was friends with him then. I'm still friends with him now. But every once in a while, if I ever see him, I just look at him and I'm like, I know what you did. I know what you did. So we got to deal with it. But no, I'm not a judge. Nope. I hung up that situation. Can I search your car? No. Yeah. Well, the situation that he was in was he had looked in, did not find probable cause, but continued to go fishing. And you can't fish. You just can't fish around in somebody's car. And he did. And I was like, dude, you can't do that. So the case is gone. Yep. Will you ever be a judge? Absolutely not. No. No, I did my time in the trenches. I'm done with that. I'm glad I did it, but I'm also, it was time to move on. When I moved on, it was time. Oh my gosh. Yes. For sure. Oh, for sure. Yes. Well, hello, Hawk. Hello. Good to see you. Yeah, that was no hesitation at all. No. I do have my own shingle, and it's a nice shingle, and I'm so happy. I've worked very hard for my own shingle. I keep it polished. I'm fine with the one shingle. It's fine. It's plenty for me. Do lawyers get paid well? No, we don't get paid well. That's a common misunderstanding. We really don't. There is the top of the pyramid in the legal community, those attorneys that are at the top that get those huge salaries that make those huge cases. Sure, there's some of those, but those are the exception. The everyday attorneys we're doing the work comp cases, we're doing the real estate contracts, the wills and trusts, the family law situations. We don't get paid that much money. I mean, we get paid probably more than, most professions, but we also, have to do more work. But yeah, we make enough to pay the bills, but is there more than that? No, I don't have any attorney friends who are out of debt that have paid their student loans back, paid off their mortgage, paid their cars. No, I mean, we're just like everybody else, we're making the money, but it's not that much at the end of the day. So no, it's really not. If you get that $1 million case, you're good to go. But if you're doing Social Security disability work, you're not going to get that $1 million case. You're working on contingency. You're going to get 35% off of a $25,000 settlement, and that's it. And the number of hours you put into that are going to be huge. We just, the numbers aren't really what most people think they are in the end. How long did it take you to pay for law school? I'm still paying. I'm still paying. Oh, yeah. I've got the loans. I've got the debt. I feel the pain, everybody. So still paying on it. That's fine. CLE courses are expensive too. Oh, they are, VC. Yeah, every year I have to pay for renewing my license, and I have to pay for all my continuing legal education, and every year also for my firm as well. So to keep everything going, and malpractice insurance. I mean, it's expensive, but, I'm not trying to say that, oh, woe is me. I'm just saying it's just reality. It's a job just like any other job. And, there's those in the profession that make a lot of money, but those are the exception. Those aren't the rules. That's really it. Full debt forgiveness. Oh my gosh. Can't understand why these lawyers risk everything to lose their license. Oh, Suze, I agree. I absolutely agree. I do not understand it. I do not understand it either. Should be interest free. Yeah, that would be nice, because that's mostly what you wind up paying is just the interest. It's one of the things you've got to love. Ava, exactly. I mean, when you're in law school, we ask each other these kinds of questions. Are you in it for the money? Or are you in it for the love of the game? And for those select few that are in it for the money, they have to live with themselves, but they can live with themselves. And I think somebody said it's easier to cry in a Rolls Royce than, in a dumpster. Somebody said something like that, but but many of us are just in it for the love of the game. And so, no, we're not multimillionaires. Most of us, we're just normal, regular people paying our mortgage, trying to make ends meet just like everyone else. But my student loans are $1,000 a month, and they'll continue to be $1,000 a month for a very long time. So, there's just not much you can do about that. Yep, the software. Never realized how much paperwork is involved. Oh my gosh, a lot. Public service in general. Yeah, I agree. Eating celery, right. I got to eat celery so I can pay my student loans back. Oh. True story, man. I mean, I feel the pain. I understand that student loan debt. I understand. I get it. I totally get it. I totally get it. 800 bucks. Yeah, Lisa, I feel ya. I hear you, man. I know. Cup of soup in college. Absolutely. Absolutely. You got to do what you got to do. 8%. Yeah. Yeah. It's that interest rate that is just brutal. Absolutely brutal. How do you think Rudy will end up years from now? I have no idea. That man, ooh, he was on a fast train to a bad place. So I'm not sure. He hasn't crashed and burned yet, but when he does, I think it's going to be pretty hard to watch. Yes, you're in the jury. Are you in the jury? Yes, I have my own law office. Yes, yes, I'm very. I'm a planner. I plan things. I was very careful about planning so that when I got to a certain place in time in my world, this is where I wanted to be. So I'm very lucky about it. Lucky and very careful planning. Very, very careful. Said too much in this mock trial. Oh, that's so funny. Well, actually, everyone, I'm kind of looking at the clock here. I think I'll go ahead and start signing off here. But as I look, I'm like, wow, I actually got to go to work again. But thank you all of you for coming and visiting me and hanging out with me and going over the Georgia case and the voir dire process here. Always wonderful and interesting to talk with everyone. Let me give you a brief overview then of what we're looking at for the next few days. We do have those demurs, right? So that's coming up in Georgia. The DC pretrial motions, I'm not sure exactly when those will be. I think they've been moved a few days. But we've got the New York criminal trial response due on Tuesday. We've got a couple things going on in DC and the Garcia hearing. So that's this week. So this is my schedule for the lives. Thank you, and fellow mods. Yes, thank you so much. All of the mods, you're just all amazing. So I will be coming back on tomorrow to go through the civil trial again. I do want to review kind of what's going on with that, just to give you an overview. It probably won't be a very long live, but 6 o'clock Central Time. And then Tuesday, I will be going through the criminal New York case. So that'll be the big one. And then I won't be back until Thursday. We'll do Florida. And then Friday will be the weekly review. So it should be a very interesting week, everybody. I'm looking forward to it. It should be a lot of fun things to learn. So thank you again, everybody, for coming. Always wonderful to see you and hang out with everybody and pick a fun jury. It's very fun. Appreciate that. I do have another YouTube video going up tonight. I should have one each day for the next few days. I'm trying to stay on top of it as best as I can. There's just not enough hours in the day, everybody. So, oh, thank you. Yes, yes. Have a wonderful night, everybody. So great to see you all. So take care, and I will be back again tomorrow, 6 o'clock Central Time, and we should have a good discussion about the civil case. So have a great night, everybody. Take care. Bye. Yes, oh my gosh. Thank you, moderators. Oh, so thankful. Yes, eviscerated. Oh my gosh. Take care, everybody.